All right, I'm going to say something that might surprise you. The Supreme Court of the United States, yeah, that Supreme Court, just made it harder for veterans to win certain VA appeals. I know. You're sitting there thinking, hold up, that can't be right. The Supreme Court is supposed to protect veterans, not make it harder for us, right? That's what I thought too, because for decades, the law has been pretty simple. If your evidence and the VA's evidence are evenly matched, if it's 50-50, a coin flip, a tie essentially, the VA is supposed to give you the benefit of the doubt. That's not my opinion. That's federal law, written right into CFR 38. It's been called the Veterans Advantage. It exists because Congress knew that when you serve your country, you shouldn't have to fight the government again just to prove what happened to you. But now, thanks to a brand new Supreme Court case called Bufkin versus Collins, that advantage just got a little smaller. The court didn't shout it from the roofs. No headlines, no viral press release, but buried inside a 40-page opinion, they quietly changed the way your evidence is reviewed when you fight the VA. And I'm not exaggerating when I say this. This decision could be the difference between your claim being approved or denied, even when the evidence is dead even. Because now, that thing we used to call benefit of the doubt, it's no longer what you think it is. And unless veterans understand what just happened and how to respond, a lot of good men and women are about to start losing appeals they should have won otherwise. So yes, this isn't just another thing. It's a shift, a paramount shift in the battlefield. And I'm going to break it down for you in plain English. No law school nonsense, no VA jargon, just straight up talk about what the Supreme Court decided, why it matters, and what you can do right now to protect yourself. So here's the deal. Every veteran, at least the ones who ever filed a claim, knows that the phrase benefit of the doubt, it's one of those rare things in government paperwork that actually sounds human. It means this: when the evidence for your claim and against your claim are approximate balance, basically a tie, the VA is supposed to rule in your favor. Not because they're being generous, but because you already carried enough weight when you wore that uniform. That's not some feel-good slogan. That's federal law. It's written right into 38 CFR. I mean, right in CFR 38. And that principle, that benefit of the doubt principle, goes all the way back to post-Civil War era. See, after hundreds of thousands of wounded soldiers came home, Congress realized something. A veteran shouldn't lose a claim because the government couldn't prove what happened in a muddy field decades ago. So they built this rule into the DNA of the VA system, a kind of moral compass, you could say. They said, if the evidence is close, if there's reasonable doubt, you got to give it to the veteran. And for over a century, that's been the cornerstone of the claims process. It's what separated the VA from other bureaucracies. It was supposed to tilt the scale towards you, not against you. But then came Bufkin versus Collins. In that case, it redefined what balance actually means. Here's what happened. There's two veterans, Bufkin and Thornton. Both filed claims for PTSD. Bufkin argued that his service caused it. The VA disagreed. Thornton already had PTSD benefits, but said his symptoms had worsened and he deserved an increase. The VA, surprise, denied both. So they appealed all the way up through the VA system and finally to the Court of Appeals for Veterans Claims, or CAVC. Now, before this case, the CAVC had the power to take a real look at the VA's decision to say, hold on, did the VA really apply the benefit of the doubt here? Did they weigh this fairly? In other words, the court could do a de novo review. That means they could look at everything from scratch, make their own judgment call. But in March 2025, the Supreme Court said, nope, that's not how it works anymore. In a 7-2 decision written by the Supreme Court justices, particularly Justice Clarence Thomas, the court ruled that deciding whether the evidence is an approximate balance is a factual question, not a legal one. And that one word, factual, changes everything. Because if something's a legal issue, the Court of Appeals can re-examine it from the ground up. But if it's factual, then the court can only overturn the VA if it finds a clear error. That's lawyer speak for Unless the VA really messed up, we're not going to touch it. So what does that mean for you? It means that the VA's interpretation of your evidence, how they weighed one doctor note against another, or how they judged your credibility, now carries more weight than ever before. The Supreme Court didn't eliminate the benefit of the doubt rule, but it made it a lot harder to challenge the VA. And especially when they fail to use it. And that little shift, that technical, quiet, invisible change in how the courts view your evidence, it might sound small, but it changes everything. Because for the first time in decades, the benefit of the doubt doesn't automatically benefit the veteran. It benefits the VA's version of the truth. So let's talk about what this actually means in real life. So I want you to try to imagine this. You file a claim for PTSD or chronic back pain or migraines. It doesn't really matter what it is. You've got two doctors saying, yes, this is service-connected, and one VA doctor saying, nope, I disagree. Before Bufkin versus Collins, you had a fighting chance. You could take that decision to court of appeals for veterans' claims, and the judges could look at it fresh. They could say, hold on, this evidence looks pretty balanced. The veteran deserves the benefit of the doubt. But now, after Bufkin versus Collins, that court's hands are tied. They can't reweigh the evidence anymore. They can't step in and say, you know what? The VA got this wrong. The only way they can overturn the VA's decision now is if they find something called a clear error. And let me tell you, that's a very, very high bar. Think of it this way. Before, if your case was a 50-50 chance, a coin flip, you had a real shot. You could say, look, the evidence is evenly balanced. By law, I win. But now, unless the VA's decision is like, say, 90-10 favorability, wrong, and obviously blatant errors, provable errors, the ruling is probably going to stand. That's the new battlefield. And it matters because most denials aren't about missing evidence. They're about how the evidence was interpreted. The doctor's report that said your knee pain started after deployment, the VA might call that less persuasive. Your spouse's statement about your nightmares, they might call that not credible. And now, thanks to Bufkin, those subjective judgments, those little lines buried in a decision, have more power than ever before. Because this decision basically says, once the VA has weighed your evidence, their weighing is actually final, unless you can prove they've made a factual mistake. And proving that is not easy. Let me tell you about the two veterans who fought this battle, right? So you've got Joshua Bufkin. He served in the Air Force. He struggled during training because of a personal crisis. His wife had threatened suicide if he stayed in. Years later, he was diagnosed with PTSD. His doctor said his condition was service-connected. But the VA said, we don't see a clear link to service. So he appealed. He fought for years. He presented medical opinions, letters from family, everything he had. The Board of Veterans' Appeals reviewed his case and said that in his case, it wasn't in balance. The Court of Appeals agreed, saying, well, the board wasn't clearly wrong. And then when it actually reached the Supreme Court, they said the same thing. That's it. Case closed. Now, the case of Norman Throckton, he had the same story, different branch. He was an Army veteran. He had already been connected for PTSD. He wasn't asking for the world. He just asked for an increase. He had years of treatment records, therapy notes, reports showing worsening symptoms, flashbacks, depressions, panic attacks, even suicidal thoughts. But the VA looked at the newer exam and said, you seem to be improving. Throckton appealed. The board said, no. The court said the board wasn't clearly wrong. And the Supreme Court, same answer. Case closed. And here's what should stop every veteran scrolling through this right now. If Bufkin and Throckton, both with PTSD diagnoses, both with legitimate medical evidence, both represented by attorneys and reviewed all the way to the top, if they couldn't get the benefit of the doubt, who can? Because this isn't just about two names in a Supreme Court opinion. This is about you. It's about every veteran who's ever sat across with CMP examiner thinking, hey, they didn't even listen to me. It's about every denial letter that says evidence insufficient. It's about every sleepless night spent wondering if the system even believes you. This decision has changed the rules of engagement. And after Bufkin versus Collins, the system that was designed to give you the benefit of the doubt just shifted that doubt back into the VA's favor. The battlefield has just moved. And if veterans don't understand what changed, a lot more good people are going to lose battles they should have already won. So what do you do about it? You can't change what the Supreme Court has already decided, but you can change how you build your case. 3 things. Number 1, you got to make your medical evidence bulletproof. Let that sink in. Look, the VA is not in the business of connecting the dots for you. That's the cold hard truth. If your VA claim is vague, incomplete, or missing medical reasoning, they'll find the hole and drive a truck right through it. You've got to make it impossible for them to misinterpret your evidence. That starts with your medical opinion. It's not enough for your doctor to write, yeah, it's probably related to your service. That's not strong enough anymore. You need clear, specific language that leaves no doubt. In the VA world, certain phrases carry legal weight. Phrases like, it is at least as likely as not, at least as likely as not. Those 5 words can make or break your entire claim because that's the legal threshold for service connection. If your medical opinion doesn't include that standard and it doesn't have a solid rationale to explain why your doctor reached that conclusion, the VA can dismiss it as speculative. And once that happens, you're right back where Bufkin was. Evidence that looks balanced to you, but not persuasive enough to them. So here's what bulletproof evidence actually looks like. Your doctor doesn't just say your knee pain came from rough marches. They explain how those repetitive impacts caused microtrauma that led to degenerative changes. They don't just say your PTSD came from deployment. They connect your timeline to your symptoms, your stressor, your treatment history, and then link it directly to your service record. That's what holds up under review. That's what survives Bufkin. And look, I get it. Not every veteran has a doctor who knows how to write that kind of opinion. Most civilian doctors, they don't know how to. They don't speak VA. They're trained to diagnose and not treat. They're trained to diagnose and treat, not to write opinions that satisfy a legal burden of proof. So what actually happens? You end up submitting a 200-word letter from your family doctor saying, yeah, I think it's connected. The VA reads it, shrugs, and says, that's nice, but denied. That's why you've got to take control of your evidence from the start. And if your claim's borderline, complex, or has multiple factors, say PTSD with migraines, chronic pain leading to depression, obesity is an intermediate step, don't go at it alone. Here at Xterra Health, we help veterans build strong evidence-based nexus letters and independent medical opinions that actually hold up. Even under the stricter review after Bufkin versus Collins, we don't just write these letters, we connect the dots the VA refuses to. We review your service records, your medical history, and your current conditions and build a logical, medically supported case that answers the exact questions the VA is supposed to ask. Because here's the truth. When your evidence is airtight, it doesn't matter how the VA tries to weigh it. You've already tipped the scales in your favor. So if you're watching this right now and thinking, that's me. My claim's sitting on someone's desk at the VA. Do yourself a favor, schedule your free consult. The link's right below in the comments. We'll take a look at your claim, your medical evidence, and tell you what needs to be strengthened. You've already done all the hard part. You actually served. Let us make sure the evidence finally serves you. At Xterra Health, we help veterans build strong evidence letters, right? And that they will actually hold up under review. And even after cases like Bufkin, you can do it. So schedule down below in the comments. Number 2. Challenge factual mistakes early. This one right here. This is where most veterans lose ground without even realizing it. Because under this new standard from Bufkin versus Collins, the VA's factual findings, what they believe to be true on the record, can only be overturned if they're clearly erroneous. Let that sink in for a second. It means once the VA decides something is fact, it becomes almost untouchable on appeal. So if they get it wrong, if they write something inaccurate or mistake what your doctor said or mix up your service dates and you don't correct it right off then and there, you've basically cemented that mistake into your record. Think about how many times you've read a C&P exam or a denial letter and thought, whoa, that's not what I said, or that's not what my doctor's report even said. Maybe they wrote that your back pain started 5 years ago when it's been documented since 2003. Maybe they summarized your PTSD evaluation and left out the part where your symptoms were severe enough to cause panic attacks and isolation. Maybe they even quoted your doctor's note, but they twisted the meaning. Do you see what I'm saying here? Those small inaccuracies, they matter more than ever. Because after Bufkin versus Collins, if those errors make it past the board level and into the appeal level, the court can't reweigh them anymore. The only way they can reverse them is if you prove they were clearly wrong. And that's a brick wall most veterans actually will never get through. That's why you have to challenge those mistakes as soon as you see them. Don't wait until you're in appeal mode. Don't assume someone else is going to catch it. When you get your decision letter, your CMT report, or your medical summary, read every line like it's a legal contract. Highlight anything that's off, wrong dates, missing records, inaccurate statements, or assumptions that don't even match your medical history. Then submit a written statement correcting it. Reference your service treatment records or your doctor's opinions that contradicts the VA summary altogether. You don't have to be a lawyer to do this. You just have to be vigilant. And the best place to do it? The Board of Veterans Appeals, because that's the last place where facts can still be challenged. Once it leaves the board, those facts are now locked in. The appeal courts, they don't deal in facts anymore, only errors. So if you're waiting to correct something after it's already been denied or decided, you're fighting an uphill battle with both hands tied behind your back. Remember, the appeal courts don't ask, was this fair? They ask, was this clearly wrong? And that's not the same thing. So here's your next tactical move. Review every decision letter immediately. Write down every single error, no matter how small. File a statement in support of your claim. You can use it on the VA Form 21-4138, correcting those details before the case ever advances. You're not being difficult. You're protecting your record. Because in this new landscape, after Bufkin vs. Collins, the smallest factual error can actually snowball into a denied claim. And once that happens, you can't just argue it later. You've got to fight smart, fight early, fight on paper. Challenge every mistake before it ever becomes fact. That's how you win under this new rule. Number 3 piece of advice, keep your own paper trail. I can't stress this one enough. And I've said it before. Every doctor's visit, every symptom journal, every statement, every piece of documentation, it all matters, because here's the truth. After Bufkin vs. Collins, your evidence isn't just supporting your claim. It's defending it now. You're no longer competing on even ground. The VA's interpretation of your story, their summary of your medical records, their examiner's opinion, they now carry more legal weight. And if you don't have a strong paper trail to back yourself up, their version becomes the official record. And once it's in their record, it's very difficult to fight it off. So how do you keep your evidence and be ready for battle for this, right? First, document everything. Every time you go to the doctor, get a copy of your visit notes. If you describe your symptoms, pain levels, anxiety attacks, sleep problems, write them down, date them, and keep them organized. If you talk about your condition with your therapist or counselor, keep track of what you discuss, not just the medical side, but how it affects your life, your family, your work, your sleep, your relationships. Because one day, someone in the VA system might look at your file and say, well, there's no record of ongoing symptoms. And you'll be able to say, nope, actually there is. I've been tracking this for years. That's how you protect yourself, okay? Second, collect your own copies of everything. Never assume the VA's record is complete. You'd be shocked how often records get lost, misfiled, or never received. I've seen veterans who had entire CMP exams just vanish from their file like they never happened. So make it your mission to keep your own archive. Service treatment records, private medical notes, VA letters, emails, even call logs. Keep them all. I tell veterans all the time, your binder of records should look like it belongs in the Library of Congress. Because when the VA forgets, you remember. Third, write your own narrative. The VA has theirs, the examiner has theirs. You need yours in your own words. Write down how your condition started, how it progressed, how it affects your day-to-day life. Describe the triggers, the patterns, the impact. This is your truth on paper, your first-hand account that no one can erase or reinterpret. And I'll tell you this, when you hand a doctor or rater a clear, consistent written account that lines up with your medical history, you instantly look credible, professional, and prepared. That's how you win under this new rule. Because the reality is, Bufkin vs. Collins doesn't mean veterans can't win. It just means, again, the battlefield has shifted, it has changed. The fight isn't only in the courtroom now, it's in the documentation. It's in your notes, your appointments, your persistence. It's in your hands. And if you understand the terrain, you can still fight smart and you can still win. So keep your records tight, your evidence detailed, and your story straight. Because when it comes to the VA system, your best weapon is your own paper trail. Okay, let's bring this all home. Bufkin vs. Collins. What is it all about? It isn't just another court case with a fancy title and a string of legal citations. It's a shift in how the VA system now plays the game. For decades, the benefit of the doubt rule meant something clear. If the evidence was evenly split, if it was 50-50, coin flip, the veteran won. The tie always went to the one who served in uniform. But the Supreme Court's decision in Bufkin changed all of that. After Bufkin versus Collins, now that is irrelevant. Now that question, whether your evidence is in balance, isn't a legal call anymore. It's a factual one. And that means the VA's version of your story carries weight more than ever before. The court said in plain terms, the Board of Veterans' Appeals gets to weigh the evidence, and unless that weighing is clearly wrong, the decision stands. So what does that mean for you? It means the margin for error just got smaller. It means you can't afford to let mistakes slide. But, and this part matters, it also means you have a clear battle plan. You can still win. You just have to fight smarter. Step one, again, make sure your evidence is bulletproof. Don't let the VA fill in the blanks or interpret your story for you. Make sure your doctor uses the right language, at least as likely as not, and that their opinions are specific, detailed, and backed by solid medical reasoning. Step two, again, challenge factual mistakes early. Once the board calls something a fact, it's almost locked in stone. Don't wait for the appeal. When you see a wrong date, a misquoted record, or an inaccurate summary, fix it immediately. You're not nitpicking, you're protecting your truth before someone else rewrites it. And step three, remember, keep your own paper trail. Every doctor's note, every journal entry, every conversation that shows your symptoms, your story, your journey, because your records are your shield. And in this system, your shield has to be strong. Bufkin versus Collins doesn't mean veterans are powerless. It just means the rules have changed. And if you understand those rules, if you know their terrain, you can still fight and you can still win. At the end of the day, this is about accountability. The VA has its process. The courts have their precedent. But you have your evidence, your persistence, and your story. And that's still enough, if you're strategic about it. So don't get discouraged. Get deliberate. Learn how the system works. Prepare your file like your benefits depended on it, because sometimes they do. And remember this fight isn't just about money or percentages. It's about recognition. It's about justice. It's about the principle that if you serve this country should serve you back with fairness, dignity, and truth. Bufkin changed the entire landscape of everything. There. Bufkin versus Collins changed the battlefield, but it didn't take away your weapon. It just reminded you that in this system, the strongest evidence always wins. Before we wrap it up, let me leave you with this. The Supreme Court might have changed the terrain, but that doesn't mean your fight is over. It just means you need to understand where the new high ground is and use it to your advantage. And in my next video, we're going to go deeper into exactly that. We're going to shift gears from courtrooms and appeals to entitlements that most veterans don't even realize they qualify for. I'm talking about SMC, Special Monthly Compensation. Most veterans think their benefits may stop at their disability percentage, whether that's 40%, 7%, 90%, 100%, but there's actually another level, one that recognizes the severity, the impact, and the sacrifices that go beyond the rating schedule. That is what SMC is. And if you've ever wondered why some veterans receive additional compensation on top of their already established rating, or if you've heard terms like SMCS, SMCK, or aid in attendance, and had no idea what they meant, this next episode is for you. It's going to break down that in plain English. I'll walk you through exactly what SMC is, how it's earned, and most importantly, how to know if you already qualify but just haven't claimed it yet. Because I've seen too many veterans leave thousands of dollars on the table, not because they weren't eligible, because no one ever told them it existed. You don't know what you don't know. So make sure you subscribe, turn on notifications, hit that like button, and join me next time, because this next one might be the one that one of the most important episodes we've done. We're not just here to help out with your